District of Ohio with the Honorable Jennifer Kingsley presiding is now in session. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have 4 cases on our docket this morning. 3 will be argued in the courtroom and 1 will be argued by Zoom. We will be taking a break following the first 2 arguments. The first case on our docket this morning is C-240607, State of Ohio versus Addison Stonewall. Is counsel ready to proceed on that case?
Yes, Your Honor. Stephanie Kess on behalf of Mr. Addison Stonewall. I'm ready to proceed.
Scott Meehan on behalf of the state, ready.
All right, thank you. The second case is C-240693, OTR Housing Associates versus Engelman. Is counsel present and ready to proceed?
Yes, Your Honor. Michael Reiser for the appellant of Legal Aid Society of Southwest Ohio.
Thank you.
David Donnet on behalf of OTR Housing.
All right, thank you. The third case is C-240625, Pillage versus Edelstein. Is counsel present?
Yes, Your Honor. Demetria DeClive here for the appellate in this matter.
All right, and I understand that Ms. Edelstein is self-represented and might be present on Zoom.
She's not present yet, Your Honor.
All right, thank you. And the last case is C-240626, Edelstein versus Edelstein. Both self-represented parties, are they present?
Mr. Edelstein is present on Zoom, Your Honor, but Mrs. Edelstein is not checked in.
All right, thank you very much. All right, we will begin with C-240607, State of Ohio versus Stonewall, if counsel would like to come forward. Ms. Kessler, would you like to reserve time for rebuttal?
I would, Judge. I'd like to reserve 3 minutes.
All right, and you may proceed when you're ready.
The place I'd like to start today is the difference between the Hall and the Barber decision, right? And I think that's going to be pretty outcome determinative in this particular case for Mr. Stonewall. And I think the Hall opinion went awry in a couple of different ways. I think where Hall first, in my opinion, misstepped is that I think it read too far into the Bruin Court's discussion of antebellum statutes. I think it's really important in the context of the Bruin decision that the court is talking very specifically in response to an argument by the government. The Bruin Court tells us they're not engaging in a wholesale analysis of the full scope of the statutes and the ones that didn't exist in the antebellum period. It's specifically addressing an argument by the government that the antebellum statutes that the government cited, that Bruin reviewed, don't support the government's argument. And I think it really matters because there's a big chunk of information that I think would be relevant that doesn't come up. So for example,
Counsel, to what extent are we governed, if at all, by the federal circuit court decisions dealing with the rights of 18 to 20-year-olds? By my count, there are 5 federal circuit decisions that address this question specifically, and they're very divergent in terms of how they look at the historical analogs for that age group. What should we do in considering those decisions with regard to Mr. Stonewall's case?
I think this court is open to make its own decision. I think those opinions can be helpful and influential, but not necessarily outcome determinative for this court because I don't think the Ohio Supreme Court has weighed in on it. I think there's that Lara versus Pennsylvania case that went up and they remanded it back, and as far as I've looked, that hasn't been decided. And this is again where I think it's really difficult to ascertain what the historical record is and what should we consider, right? And this is in Bruin, they talk about, well, I think somewhere between 5 and 9 states at the time had enacted CCW statutes. And I think the Hall Court says, well, I mean, that's pretty across the board, so this seems to suggest that this was viewed as okay. Well, that doesn't account for, I think, by the time the Ohio statute was passed, there were about 34 states in the union at that time. So if we're saying 7 of them had statutes, well, what do we make of the majority which didn't, right? Are there legislatures that considered it and said, no, we're not going to pass this within our state because it's inconsistent with
Counsel,
the Second
while I
Amendment
understand
language?
that you're getting into the historical analogs and trying to determine like what's relevant, what's not relevant, what was in existence in different states, there's also sort of an overall arching a discussion that's presented by the state and presented by Hall and also presented in other cases that simply has to do with the concept of regulating access ownership versus manner. And so as it goes to your first assignment of error more specifically, that differentiation and the fact that it's simply regulating manner and the argument that that then makes it permissible and is not inhibiting Second Amendment rights, how would you address that portion of it? So I'm pushing you up like one level higher before you.
I appreciate it,
Yeah,
Judge.
yeah.
I think that's the test, right? The test doesn't say, examine what the state could have done, right? I think in the Hall decision, there's a lot of conversation about, well, the state can ban concealed carry for everyone, so therefore it's fine to just do it to a more narrow group. But I think that answers the Bruin question incorrectly. I think the Bruin second question is whether the challenge regulation is consistent with the historical record, but it's the Ohio challenge law.
So are you saying that that sort of analysis is not relevant, that one should should rather jump into the historical analogs? Is that what you're trying to say, or am I misunderstanding?
No, I think the question, right, that has to be answered for Bruin is Ohio's current statutory scheme that disallows 18 to 20-year-olds, among others, is that specific carve-out consistent with the nation's historical record?
Well, I think what Judge Zayas is asking you is, isn't there a step one? I mean, Bruin compels us to answer the question at step one, whether the regulated conduct falls within the scope of the Second Amendment. So does a manner restriction fall within the scope of what's protected by the Constitution?
I would say yes, a manner or regulation as to manner or who both falls under the Second Amendment. And I think that the answer to the first question, which I think is consistent, in Hall and Barber is the same. But it's that second question that I think is where I think I'm trying to answer your question.
Okay.
Is what is the current regulation? Because that's what we have to compare to. So does it matter that it's a carry concealed regulation as opposed to a straightforward prohibition? Yes. The state doesn't have to justify historical regulation that has anything else to do with that is beyond or outside of the current regulation we're looking at. And the current regulation we're looking at is Ohio's current statutory scheme, which isn't a wholesale concealed carry ban. It distinguishes it. So I would
So
argue.
I think what I'm understanding, what you're saying is that we should be looking at the statute that governs qualifying individual, and that this disqualification based on age, whether there was historical analogs.
Yes,
Is that
that's
right?
what I would agree.
So what's interesting to me on that and this was raised, I believe, in Watley and in other cases that have come before us. What's interesting about that is that Rahimi gives Bruin some context and says, well, we're not looking at, sort of like a mirror image. So so the question is, how will you distinguish that to like that is not pushing it further than Rahimi wants it to be pushed in defining Bruin?
Understood. And I
Okay.
think it matters. I think there's a case I cited too out of the Eastern District of Virginia where the court does a good job of saying there's no historical analog back at the time that disarmed 18 to 20-year-olds. So in terms of how do we deal with this, we have new facts now, or new ways of thinking about things, and how do we deal with that within the context and not making sure we're too rigid, right, with the interpretation. I think that's where the hand pistol language is interesting, right? Because I think Bruin addresses it, that weapons at the time, these hand pistol, pocket pistols that would have considered to be very dangerous then, well, they're commonplace now. So that would be, if we were to say, well, because pocket pistols were considered very dangerous and abnormal then, we shouldn't allow them now, I think that's what the Bruin court would give us an example of how to work within the statute without holding it too narrow.
What's your understanding, because Bruin compels us to look at both burden and justification, both now and in history. What's your understanding of Ohio's justification for permitting 18 to 20-year-olds to openly possess firearms, but not to possess concealed firearms? Why is Ohio doing that?
Based on my reading of the cases, I would agree with, I think as Barbara Coach suggests, that it's an age-based, it's a danger-based restriction, right? Because we have these historical analogs that everybody putting pocket pistols in their pockets, this new scary event because you can sneak up on somebody and assassinate them, right? And I think the current Ohio law does not reflect a general wholesale fear of everybody having pocket pistols and surprising people. Ohio's made a very deliberate decision to say, you know what, without coming in, without having to apply for a license, without having to take any steps.
So I'm sorry, I just want to actually drill deep into this so that I understand Ohio's actual justification for its regulation. The belief on Ohio's part is that an 18 to 20-year-old would be more likely to use a concealed firearm in a dangerous way? Is that what's animating this statute?
I think that's a reasonable interpretation of the law. I can't say that I've read the legislative package of history behind it, so I want to be careful not to misspeak, but yes, I think that's.
Is that something that we should do?
I mean, I think from a policy standpoint, unfortunately with Bruin on the table, I don't think courts have a lot of room to decide policy. I think we have to apply Bruin, even if the outcome is maybe a little bit odd. So
Well,
here,
Bruin is telling us that one of the starting points is to understand the current justification. So how would we do that?
I mean, I think you could look to the legislative record. I think you could look to what the legislation has said about it. And I think other than that, I don't know that there's much else that can be done. So, I mean, if we're in a case where they've not specified why they did that.
Well, and the
Yeah.
challenge is, of course, Ohio, there's not really a way to go back into legislative intent, the way there might be in other jurisdictions. So keeping that in mind, if one were to look at the, what was being sought to protect or what was the intent with the historical analogs, can one then look at the current statutes and say, does this statute seem to, to facilitate the same intent? Would that be a potential approach,
I think
given the limitations we have in Ohio?
I think you could. I think you could really do that in context of who else is not a qualifying adult, right? I think it's mental health issues. I think it's people with certain convictions, if I recall correctly. So I think you could read the statute to say, okay, clearly here they're intending to exclude some people from automatically getting this license. And the common denominator between the bunch is whether or not they're dangerous. But I mean, that's
Yeah. Because
step
putting
one,
Barbara
right?
aside, I'm going to put Barbara aside for a minute, and I understand where you're reaching into there, and I understand why, okay? It seems as if a lot of the case law that has developed when you're dealing with those under 21 is that it seems as if the concern is more about the maturity and the decision-making of an individual who's under 21. As opposed to the inherent dangerousness of that person carrying a certain way or going to the second statutes, transporting a firearm a certain way. So I would love your perspective on that, on the development of looking at under 21 dealing with decision-making and maturity.
I mean, I think under the old means and scrutiny, that would matter a lot more, right? Because then if the state has a legitimate reason to do something, that carried weight, right? Like the legitimacy of it, was it a good decision? Does it affect public safety? All of those would have mattered. But I think the value, the rationale behind it, whether it increases public safety, is out the window under Bruin. It's just, do the hows line up? Do the whys line up? Whether they're good or bad, do they line up? And so I think that's the major change that I've seen, I think, when we start talking about policy and whether it's well-founded, well thought out, whether it's effective. I think Bruin just took all that off the table.
And Counsel, you're out of time.
Thank you,
Thank you
Judge.
very much.
Morning. May it please the court. Let's start with the very first step, and that is whether or not Mr. Stonewall's rights were infringed upon. They weren't. He's allowed. It is a he, isn't it? I'm sorry. I'm trying to remember. In my head it was Stonewall. he is allowed to carry a firearm. He just has to openly carry it. He doesn't like that he can't concealed carry it. And when he turns 21, that will change and he can.
Well, is that a faithful interpretation of Bruin? I mean, doesn't Bruin direct us to look at how the regulation impacts Second Amendment protected conduct? It doesn't tell us to look at what other conduct might be permitted. It tells us to look at the impact of the challenged regulation on the Second Amendment right. So if we do that, can you address how this regulation might affect the right to keep and bear arms?
Doesn't impact it at all. It just says where you get to keep it. Just you can't keep it concealed in your pocket. And there's no Second Amendment right to concealed carry. To bear arms, absolutely. To carry them concealed, no. And while there's been a lot of the federal courts that you talked about that have looked at the 18 to 20-year-old question and said they're allowed to buy guns, they're allowed to have these guns, and the prohibitions that prevent them from buying and having these guns, that these run into constitutional problems under Bruin. Courts that have looked at it for the concealed
What
carry
if we
have gone the other
said,
direction.
let's just test the bounds of this, right? So what if we said you can't keep guns except on Mondays, or you can't keep guns loaded, or you can't keep guns unless they're smaller than 6 inches? I mean, what if we started regulating all different manners of keeping?
Well, on the first two, the only on Mondays, well, then you're saying 6 days of the week, you don't have the Second Amendment. If you're saying that you can't keep them loaded, I think when you look at Bruin, the whole point was to be able to keep the firearm for self-defense purposes. That's taken away at that point. The 6 inches where you get into short versus long guns, handguns, and it's a whole nother, I'm not ready to answer that because that's a whole different mess.
So how
But-
do we know the difference? How do we know that this regulation is of the manner variety and doesn't cross over into the banning variety? What's the line? What's the legal test?
No one is telling Mr. Stonewall that he cannot have a gun. He can have a gun. He just can't conceal it. That's where the line is that are we saying you can't? We are not. We are saying you can have it. You just got to carry it openly. If you want to go
Well, what's the difference between that regulation and the Monday regulation? He can still have it. He can just have it on Monday.
he can openly carry Monday through Sunday. Under your scenario, he would only be able to carry it openly or concealed 1 day a week. That's where the difference is. At some point, we're saying, if this is my gun, I can't have it 6 days a week. I can only have it one. I have to be able to have this all 7 days of the week. It's just a matter of whether or not it's in my pocket or if it's out in the open.
So you're saying it's too much of an infringement on everything is coming down to self-defense for the most part, on your right to self-defense if you don't even have access to the firearm 1 or 5 days a week, whatever.
Right, yeah. We can't tell somebody that you can only have the gun itself under limited circumstances. We're not doing that. We're just saying you can't carry it concealed until you turn 21. And when you look, if you go beyond that, if you look at the history and tradition and you look at what the rules were for those who were under 21, it's actually a modern interpretation that someone that's 18 or older is suddenly considered the age of majority. When the nation was founded, the idea of letting 18-year-olds vote was mocked. And anyone who was under 21, 18 to 20-year-olds, they could join the military if their parents let them. The parent could then revoke that privilege and say, you know what, we've changed our mind, Army, you no longer get our kid. And when those...
Can you help me understand how that line of regulation or that line of historical law is relevant under the Bruin regime? Because as I read Bruin, it tells us to start with today's justification and to try to figure out and ascertain what that is, and to look at today's burden on Second Amendment rights and to try to figure out what that is, and then to look backwards and try to find some historical analog, not twin, but analog for both of those things. So how would it come into the scope of our Bruin analysis as to what historically minors could and could not do with respect to other rights, like voting or contracts?
Well, because when you look at the rights that they had involving guns, they weren't allowed to have them unless they were under strict supervision. So if you go back to the founding, Mr. Stonewall wouldn't have been allowed to open, concealed, he wouldn't have been allowed to carry it all unless he was in a situation where he had been put into the military, into a militia. At that point, he's being compelled under supervision, so by the government, who's then stepping in, acting in loco parentis. That's the difference, is that if you go to that step, he wouldn't have been allowed to.
And is that tradition one of regulation, one of prohibition, or one of simply enabling parents? Do you understand the question I'm asking? So were there laws on the books that said children cannot possess firearms and it's unlawful to do so? Or were the laws more in the nature of saying parents can make decisions with respect to children?
At that point, those children under 21, as they called them, infants at the time, didn't have any of the rights. I mean, they were equated with, and this is the historical words, not mine, idiots and madmen that were considered too dangerous to be able to possess these things.
So, I mean, if I recall, your position is ultimately that it has to go to, again, the maturity and the decision-making of someone who's under 21. And that appears to be the underlying.
I believe that is the underlying rationale for the prohibition on concealed carry for the 18 to 20-year-olds in Ohio.
Where would we find that modern justification?
I don't know where you're going to, because as
This
we
is
said,
kind of assumed by,
I'm assuming it based off of the nation's history of as well.
but there's nothing in the Ohio statutes that says.
No, the statute does not say we're saying no 18 to 20-year-olds because we think they're dangerous. I'm just going off of what history, and if I can step outside the scope of the record on appeal, my background in psychology says until you get to your 20s, the frontal cortex isn't fully developed to the point where you can appreciate the long-term consequences of your actions.
So that's the modern version of the infants are idiots.
Yeah.
Yeah.
And is that consistent or inconsistent with Ohio's position that people in this age group can openly possess firearms?
I can't speak to why they felt that that was different, other than the fact that we have made some changes as to what we consider the age of majority from the time that both from when the Constitution and when the 14th Amendments were adopted, that we've made changes as to what we consider to be the age of majority. But again, the legislature made that call and found that this group of people fits all the other ones they found were not qualified to carry guns, and said that these are not the people we want to be able to carry a concealed weapon.
This is what makes it interesting. In addition to Ohio, we don't really have anything to turn to for legislative intent, without secondary sources and things of that nature, is that if what we had in front of us was legislation that was as restrictive as the historical analogs, right, then it would be much more difficult to come out with the finding of unconstitutionality. But now, because we have something that is less restrictive than the historical analogs, then how does that weigh into the constitutionality? It just makes it very interesting.
It makes it interesting, and it shows how difficult Bruin, which is perhaps the most subjective legal test I have ever seen in my career, is to apply in the real world. And with that, let me just conclude with this, and that is that whatever you decide today, the loser is going to take to the Ohio Supreme Court. And if you look, I actually made a chart, color-coded and everything. Since Striblin, which is the case that the Supreme Court is accepting and holding everything for, they're accepting and holding. Even Hall, last week I filed the memo and op, and it was a memo and partial op, because the first propositional law I felt was nonsense, but the second one was all Bruin. I was like, yep, you need to take this. You need to take this and hold it, because that's what you've done with all the other ones where there was a legit Bruin question. And if you look over here, all the pink, that's all every one of them where there was a legit Bruin issue, and every single one of them has been held for Striblin. So what I would encourage you to do.
And this is all first district cases, your chart? Your chart is all first district, or is it state of Ohio?
State of Ohio.
Okay.
And how long, Do you have, does the state of Ohio have an expectation about when they're going to decide?
Striblin, it's set for argument in October, so how quickly they decide it from there, I don't know. I
Well,
also,
counsel, I mean, I appreciate you raising that issue, and we're certainly aware of it as well. But even, even beyond what the Ohio Supreme Court might consider, Bruin comes from the U.S. Supreme Court.
It does.
And there are additional developments occurring in this body of law around the country, including a current circuit split on the 18 to 20-year-old issue. 5 federal circuits have considered it. They've treated it in radically different ways, and the Supreme Court declined to intervene in the Worth case, which did find a ban on public carry by 18 to 20-year-olds passed by Minnesota to be unconstitutional.
and that's public carry.
Right.
And I think that, and again, when you look at the cases, the federal, other states, I did a national search yesterday. When you look at the whole 18 to 20-year-olds can't even have guns, that's where you're getting that split. When I narrowed that to whether or not there was any kind of split on 18 to 20-year-olds with concealed carry, no split. There, the universal decision has been the concealed carry doesn't cause this constitutional problem.
Well, there is a split currently on the federal law banning purchase,
Yes.
which to me could be conceived of as a manner restriction because it's simply purchase, it's a manner of access, it's not possession.
I
Can
think
you address that?
Sure. I think, again, that kind of goes back to your Monday it's okay, Tuesday it's not. If you can't purchase it, then you're, again, possibly depriving someone of their Second Amendment right that Bruin recognized to defend yourself. Whereas, again, whether or not you openly carry it or concealed carry it, that doesn't change whether or not you are able to defend yourself. You
So-
still are allowed to have that weapon to defend yourself, and that's what the Second Amendment
So
in
is your
Bruin goes to.
position then that this isn't a Bruin case at all? That really at step 1, this doesn't trigger the Second Amendment at all, and we shouldn't even engage in Bruin analysis?
Yeah, and that's where I started, that the Second Amendment does not give you the right to carry a concealed weapon. It gives you the right to bear arms, not to bear concealed arms.
If I recall, and I may be recalling it correctly, I believe in Watley or in another case, the state actually conceded step 1 and went to step 2. If I'm correct in my recollection, what do we do with that, considering that now you're doing
I'm
the
sorry.
complete opposite?
I couldn't hear you.
I believe in other cases, and I believe Watley may have been one of them, the state conceded step 1 and went to step 2. So what do we do with that, with this case where you're not conceding step 1 and you're arguing step 1?
I think that's where you tell me if I'm right or wrong. Again, I just don't think that the Constitution gives the right to concealed carry. But even if it does, when you look at the history and tradition, if you look at the laws, and you look at the differences between the 18 to 20-year-olds who are allowed to purchase or possess versus how they can possess, there's a very bright line between those. And what is Ohio's law on concealed carry is absolutely constitutional and should be upheld.
Thank you.
I don't agree that it is clear from the text that it bars concealed carry. I think that's the question, right? Is it covered under the Second Amendment or is it not? And that's where Bruin, I agree with the state that, sure, the test looks easy, applying it as anything but, which is why we're seeing all of these circuit splits and everybody's looking at different things, reading it differently. The application of it's extremely difficult. And of course, we have the predictable field that we have. But when we look to, okay, well, what did the founders, because Bruin has told us that that's what matters, what was the understanding at the time, how do we decide what that was, right? And this is where I think the antebellum statutes become somewhat of an issue. The first one that gets discussed is the Kentucky one, and that's the one where they found that you do have a Second Amendment right to concealed carry. And then as time progresses, as we get close to the Civil War, as violence spikes, as these dangerous pocket pistols become more commonplace, now we start seeing legislatures stepping up to solve this problem.
So
What-
are you saying that I'm going to change the historical analogs, and let's say the historical analog says, yes, concealed carry is fine, okay? Are you saying this carve-out is just not fine because it's fine for everyone else?
That's where it gets tricky, right?
Because
How
it
do you
seems like you're
fully-
looking at the underlying purpose of the statute as opposed to the underlying purpose of the carve-out.
And I think to answer that question, it goes back to how do we apply the Bruin test? And it tells us to apply the law as it's written. And do we have an historical analog? And again, it doesn't have to be a twin, but do we have a historical analog that matches the hows and whys of the older one? So we have Ohio making these carve-outs. That's what we're trying to find analogs for. We don't have to find analogs for a complete ban. We don't have to find analogs about whether it could or couldn't disarm different people. The Ohio current statutory scheme doesn't allow concealed carry for these specific carve-outs. Is there a historical analog that has these specific carve-outs, or ones close to it, or ones that have the same justification?
So I
and
think
what
where you're
people have
differing with the
different?
state is that the way that they're looking at that carve-out is they're looking at broad legislation of that group, of the under 21 group. You're looking at the carve-out and you're looking for historical analogs that are with regard to firearms, concealed carry, or carrying in a vehicle, or transporting in a vehicle for the under 21.
Mhm.
So it's basically comes down to how does one apply Rahimi, which it sounds like to me,
I
right?
think so.
Yeah.
And I think that that's what they talk about. The historical analog has to be a firearm regulation. The current one has to be a firearm regulation. So I'm not sure that any bars regarding anything other than firearm regulations come in under the Bruin or Rahimi test. So if there are no further questions, I think we're good.
Thank you.
Thank you.
Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. The second case on our docket this morning is C-24-0693, OTR Housing Associates versus Engelman.
Morning, Your Honor.
Good morning. Would you like to reserve time for rebuttal?
Yes, Your Honor, 5 minutes.
All right.
Will be fine. May it please the Court, my name is Michael Reiser. I am with the Legal Aid Society of Southwest Ohio. I am here today representing the tenant in this matter and the appellant, Damia Engelman. The primary issue in this case is the first assignment of error of Ms. Engelman's, where the trial court issued an immediate writ of restitution without holding a hearing on the merits of the case, of the eviction case that was filed by the appellee OTR Housing.
When you say a hearing on the merits, do you
Yes.
mean a trial?
I mean a trial as to whether the plaintiff has met its burden and is entitled to the writ of restitution, and an opportunity for the defendant to present defenses, affirmative defenses, to their case in chief. Yes.
And you're arguing this under statutory section 1923.06H?
Yes, as well as the constitutions of the state of Ohio and the federal
Okay.
constitution, because a tenant such as Ms. Engelman has a constitutionally protected property interest in her tenancy. And to take away that interest requires her the opportunity to present evidence and assert defenses at a
I
trial.
want to make sure I understand exactly what happened here.
Yes.
So I understand that the rent bond had been set, and then at some point, there's an allegation that it was not paid.
That's right.
And then this contempt motion and another suite of motions was filed.
Yes.
And then it was summarily granted.
Yes.
And at any point, was there a hearing pending
No.
that was then canceled, or there was just no hearing set to occur at all?
There was no hearing yet set. How these, when a jury demand is filed and the rent bond is set, it gets transferred from the magistrate to a municipal court judge, and then subject to the municipal court judge's calendar, the case progresses. In this case, a trial had not yet been set.
So the case was sort of in like a no man's land awaiting action by the municipal court judge?
Sure, I think one conference had occurred, and I think that at that conference, I wasn't the one who attended that conference. I think at that conference, it was acknowledged that rent bond had not been paid and a motion was going to be made to strike the jury demand.
And everyone left that conference with no further setting.
That's my understanding, yes.
So there was no hearing on the pending motion?
There was no hearing on the motion, the subject motion that resulted in the entry that has been appealed, correct? It was just just the papers.
But the motion requested the relief that was delivered. That is, it was not just striking the jury demand, it was basically a judgment on the merits.
Yes, with only the complaint filed, there was no evidence before the court to make such a decision. Yes.
And had an answer been filed to the underlying eviction complaint?
Yes, on August 22nd, 2024, an answer had been filed raising, I think, 6 or 7 affirmative defenses. Yes.
Right.
Yes.
Thank you for going over that.
Sure. Okay, so on the first assignment of error, I think it speaks for itself is that we believe a tenant in Ms. Engelman's shoes is, no matter the outcome of the jury demand bond not being met, at the very least, the proper remedy would be to strike the jury demand and consider it waived, and then proceed to a hearing on the merits of the actual eviction action.
So that would be relief on the motion, that would be like a contempt, basically a contempt remedy, where the judge would strike the jury demand, set it for a jury trial. Would your client have a chance to purge that contempt and reestablish the jury demand?
Yes, I would argue that, yes. In this case, that's what Ms. Engelman asked for in her response to the motion, was to reinstate the jury demand by coming current on the rent bond. Instead of a hearing being held on that actual issue, whether the rent bond could be reinstated, which is something that we asked for, that was also ignored and just the writ was issued. So we asked for the opportunity to. When this court granted a stay of proceedings, Ms. Engelman deposited all necessary funds into court, and the stay was granted by this court. So yes, our position is that her opportunity to purge her contempt and the municipal court judge saying, you have waived your jury demand. Our position is that, well, we would like the opportunity at the very least to explain why the jury demand bond was not paid in a timely manner. In this case, Ms. Engelman alleged that I had lost my job and I had to make a decision between utility bills, and I had to do that, but now I have the money. So can I please have the...
The reason for the eviction, though, was non-payment of rent, correct?
That's right.
So assuming that there had been a bench trial or a jury trial, what was the triable issue? If anything.
Yes, so Ms. Engelman had multiple notice defenses primarily. First and foremost, there are federal regulations requiring that particular forms required by the regulations from the Violence Against Women Act, a certification form that you're a victim of domestic violence, and the rights that are attendant to you as a result of a tenant who's facing domestic violence. In all eviction actions concerning a housing choice voucher case, which this case is, a federal housing choice voucher, need to include those forms in the notice. Otherwise, there's failure to comply with that federal notice requirement, necessitating the dismissal of the eviction action.
Even in the face of failure to pay rent, those notice requirements would cure the failure to pay rent portion of the...
It wouldn't necessarily cure assuming that the rent payment was not in dispute, they would necessitate dismissal of the action and a new action would have to be brought. It wouldn't be a dismissal on the merits if dismissal was obtained on a notice defense.
So that's what would have been presented at trial, basically a notice defense under a federal eviction proceeding, because...
That's one of them, but also in cases like this, what sometimes can happen is that the tenant can come up with the back rent and offer it at trial. And there is a local municipal statute, too, that is called pay to stay, colloquially, that we also could have raised at trial, too.
Was that asserted in the answer?
It was not asserted in the answer. I don't think it was asserted in the answer, but there is a statute in the Forcible Entry and Detainer Act, that permits a tenant to raise any defenses at trial, regardless of whether they're in a written answer or not.
So typically, how fast would something like this be set for trial in municipal court?
It depends on the judge. It can be, I know some judges issue trial scheduling orders that are in the range to 6 or 7 months. Dave might be able to speak to this a little bit too here. Other times, it can take quite a bit of time, depending on whether discovery is occurring or if motions for summary judgment are filed. Again, these are dependent on the jury bond payments being made the entire time to preserve any damage to the landlord plaintiff.
And it sounds to me like some of the things that you're discussing that could have been presented aren't necessarily defenses that perhaps fall more under the umbrella of remedies.
I'm sorry, could you?
Like you talked about the pay to stay.
Sure.
I don't think the pay to stay doesn't sound to me like that's a defense. It sounds to me like that's a remedy.
A remedy to the motion made
Like
by.
in other words, a remedy that's available for the trial court to invoke.
Sure. I'm not sure.
In lieu of the immediate, you understand what I'm saying? It's not really that important, but it is kind of important. Because I think what Judge Nestor is really bringing out is like, what was the harm in his questioning? I'm assuming here, but it felt to me like that's where you were going.
Sure.
And so, and then looking at what would have been pled or not pled. If you're defenses versus remedy, there's a difference there.
Yeah, I think that a remedy and a remedy that could have been issued by the.
In other words, I don't know that a remedy would need to be pled.
Yes. Okay. I understand. Yes, I do agree. I agree with that. Yes.
Okay.
And I just want to speak briefly on the second assignment, which we've kind of hit on here, is that the court at the very least, and there are cases cited in the brief too, should have given Ms. Engelman the opportunity to come and explain why the rent bond was not paid, to give her the chance of reinstating her jury demand and continue the case as it had been proceeding, and give her that opportunity to deposit that money into court. Now, if the judge didn't like the reason, then I think that the proper outcome in the case law, I think in the statutes and the constitutions support that what properly should have happened was to consider the jury demand waived and then set the case immediately for a non-jury trial.
Thank you. You're out of time.
Okay. Thanks, Your Honor.
If it please the court, David Donnet on behalf of appellee. The issue I think this court needs to look at and address is what rights does a landlord have, and when a court order is issued, what happens when it's violated? And that's what's before this court today.
It seems like they might concede that striking the jury demand is a proper remedy. It's just that there wasn't then a trial on the merits.
My argument would be that there was no need for a trial on the merits. This case was a non-payment of rent case. In the memoranda contra to my motion to strike the jury, the case, they admitted that the tenant had not paid rent.
Well, okay, there are a few procedural vehicles for resolving a case on the merits short of a trial. One would be motion for judgment on the pleadings. Another would be motion for summary judgment. Were either of those filed here?
No.
So what evidence was then before the court that would enable it to reach a merits determination?
There was the motion to strike the jury, which indicated that the bond had not been paid, non-payment of rent. The case is based on non-payment of rent, and the memorandum in response admitted she hadn't paid the rent.
But striking the jury demand and granting that motion doesn't then equate to a judgment on the merits. Would you agree?
It could, yes.
I mean, the trial court, it seems to me, then exceeded the relief that was requested.
No, because the relief that was requested was strike the jury and issue a writ because the tenant is 2 months behind on the bond and is in contempt.
And what was the procedural vehicle through which the writ was requested?
It was the motion for contempt, which was to issue the writ, strike the writ, and, issue strike the writ and issue an immediate writ. Now, granted, some judges will, in response to that, strike the jury demand and refer the matter back to the magistrate. Some of them will set it for a hearing.
Is that, so when it's referred back to the magistrate hearing in this circumstance is typically the trial on the merits?
It's a trial on the merits.
So usually in these cases, the landlord files, it gets set for an immediate hearing, there's no trial demand, and it's in the nature of almost a default. Is that fair?
Yes.
But in this case, the person actually asked for a trial.
But they waived their right to that trial by failing to
Well-
post the bond and being found in contempt.
Okay, so what authority do you rely on for that proposition?
The bond statute, 1923-08, mandates that if the case is going to be continued for more than 8 days, then the matter is to be, a bond is to be posted.
Is that consistent with principles of due process that a person would have to pay in order to have an opportunity to be heard in court?
Yes, it's the statute. It's statutory
Well,
requirement.
that's as to a jury demand, but as to an opportunity period to be heard in court, that they have to pay.
I'm not sure I understand the question, to be honest with you.
Well, the argument here is that when the jury demand was, we'll call it forfeited, by not paying the rent bond, that what should have happened is a trial to the bench, an opportunity to be heard.
That's discretionary with the judge hearing the case.
What makes that discretionary? I think that's the question. Does 1923-08 say, upon failure of posting bond, a judgment shall be entered?
It does not.
It basically, what does it say? It says,
It simply says that the bond must be set for and continued for, while the case progresses, for the ability, if the plaintiff, in this case the landlord, prevails, that the matter will be.
so if the plaintiff landlord prevails, doesn't that imply that there's going to be some sort of determination on the merits in a trial? I mean, it just goes back to the magistrate, and so it could be a lot faster in this circumstance because there's no need for a jury.
But it goes back to what can the judge do when they find the tenant in contempt for failure to post the bond?
Well, in any circumstance, have you
And a contempt
found?
order can result in a judgment.
Do you
And
have other examples of that where contempt resulted in judgment without trial? I mean, I understand that contempt oftentimes makes it very difficult at trial to present certain arguments or have certain evidence. However, usually there's a trial on the merits.
Well, I mean, to give you an example, I had a phone conference this morning with a judge, and the order to do that phone conference says failure to appear can result in a contempt hearing and a dismissal of the case, which is a hearing on the merits at that point, or the equivalent of it. It depends on the judge. In this case, the second issue that was raised was an abuse of discretion. The judge looked at both our motion for contempt and defense motion for a response, and found there was no need. The basis of the case was non-payment of rent, and 3 or 4 months into the case, they stopped paying rent again.
So you're equating what's in essence a failure, of dismissal for failure to prosecute equivalent to a judgment on the merits?
I'm equating a failure to post the bond and a hearing, a finding of contempt, not so much as a judgment on the merits, but as a dismissal of the plaintiff, the defendant's case, as part of that contempt order. And that ends up in the issuance of a writ.
So in essence, what you are saying then is that if a tenant does not pay the rent bond, they risk forfeiting their entire ability to defend the eviction action.
They do. I mean, at some point.
And is that consistent with principles of constitutional due process?
In the fact of a civil case, I think the answer is yes, it is.
I mean, does a tenant have a property interest in their leasehold?
They forfeit that property interest when they fail, if they have a property interest, they forfeit that property interest when they fail to live up to the court's order. The question is, how does
Isn't that circular, though? Don't we have to find that they failed to abide by a court order, and don't they have an opportunity to be heard as to whether they did?
in this, evictions stand outside of normal procedures. And I think in the case.
Why is that?
Because it's an extraordinary procedure that virtually none of the civil rules apply to. Civil rule.
I'm asking you about constitutional due process. When a person has a property interest, they have a right to have that property interest not taken from them without due process of law. And that's been raised here.
I understand that, and I disagree with that position. I think by finding of contempt, they waive that property interest when they fail to make the payments.
Here's one thing I want you to address with regard to the position that you're taking. Arguments and arguments presented in motions are not actual facts and are not actually, are not part of the record for consideration on the merits. So there has to be a factual presentation. You can't just have arguments and arguments substitute for a factual presentation. So here, because there's no hearing on, then how can the court make a determination on the merits when there hasn't been a factual presentation? There's been only, because you said earlier that it would be determined on the motions. So what am I missing here?
When we file the motion, we attach a copy of the docket that shows, based on the court record, whether or not the payments have been made or not. And in this case, the payments were not made.
So the trial court would be also making a determination on the authenticity, the credibility, the accuracy of those attachments, absent anything, because again, anything that's presented in the motions is not to be considered on the merits. The other question I have that's tied to this is, it feels as if you're saying that there could be almost like a sua sponte motion for summary judgment by the bench. And so where would that be rooted in?
There have been judges that have done that, sua sponte, stricken the jury demands.
I'm talking about a sua sponte motion for summary judgment, because in essence, what you're advocating for is either a motion on the pleadings, sua sponte, which doesn't seem to be rooted in any of your arguments, so it feels more like you're talking about a sua sponte motion for summary judgment.
I think it's the equivalent of that, yes.
Because then it's starting to feel as if you're asking the trial court to be an advocate too, because now they're stepping into the shoes of counsel. So in addition to the constitutional and all the rest, these are just things that I'm trying to understand as I'm wrapping myself around your argument.
Again, I think the question is, when does the court have the ability to enforce a court order? That's our position. And how does one enforce that court order?
Well, wouldn't enforcing the court order here have looked like striking the jury demand? I mean, the statute is pretty clear that when the jury trial is going to occur beyond the 7-day limit in the statute, that a rent bond can be set and that failure to post the rent bond can forfeit the jury demand, right? So
Correct.
a literal application of the statute and the case law would have resulted in forfeiture of the jury demand, and that's it.
Which is what happened here. We asked for the court to issue the writ because at that point, without the jury demand and the issue of non-payment of rent, this court chose to do that.
And could you have filed a summary judgment motion supported by affidavits and verified evidence?
We could have, but in this case, by the,
And then would that have given Engelman an opportunity to respond with evidence and verified information and affidavits?
But in this case, Egelman responded. They responded to the motion by saying, yes, we haven't posted the bond, we're behind in the rent. I mean, I think that's where the court...
With arguments made by an attorney. I'm talking about evidence that would have allowed the court to reach a merits-based determination.
That could have happened, yes. This court chose to look at the motion and the docket showing that the bond hadn't been posted, and the counsel's response saying, you're right, we haven't posted the bond. And again, the issue isn't why you haven't posted the bond. The court order is post the bond, and in reality, there's no excuse for not posting.
And the remedy for that is striking the jury demand, not canceling all process which would allow a person to defend themselves, right?
Well, again, I think the court ruled correctly in doing both, striking the jury demand and issuing the writ, because the documents before the court showed that it was basically on the part of counsel an admission that no rent had been paid. Any further question?
No.
I would point one thing out that was raised just as a periphery. Cincinnati Municipal Court has issued this pay-to-stay thing. It's not being enforced, and the state legislature issued a 532120 statute. It's the first amendment since I've been practicing to the Ohio Landlord-Tenant Act that basically says that's unenforceable.
So the pay to stay, is that a ordinance from the city of Cincinnati, or is that a
It's a city of
statute from the
Cincinnati
state?
ordinance.
It's a,
But 532120 is the statute. And basically, the 40 years I've been doing this, the landlord has the right to refuse late rent. And what that ordinance says is, no, you can't.
But Mr. Donnet, that issue of any conflict between state and municipal law is not before this court.
No, and I understand that. It was just raised, and I thought I would clarify something.
so I think what you're saying is that that's not a viable remedy.
No, it's not.
Okay.
Thank you very much.
Your Honor, just very quickly, I think the appellee is focusing very heavily on 1923.08, which is the continuance statute for longer than 7 days, if a continuance is longer than 7 days. Judge Nestor did point out correctly that it does not include a provision that says judgment will be issued to the plaintiff if the bond is not paid. I think, again, just going back to proper remedies.
And your argument is rooted in 1923.06. I know the Constitution as well.
Yes, of course.
H that has shall language.
Yes. Yep.
What portion of 1923 or What do you cite to for the proposition? You told us that you can raise any defense at trial. I understand.
Yep.
It's intended to be a summary proceeding, so I imagine that the law was to allow that defense, any defense. Where is that?
Sure. I think that, well, it's 1923.06H1 requires that a hearing on the merits must be held when a landlord brings a claim against a tenant. Hold on one second. I'm sorry. I'm in the wrong place here.
I mean, the whole point with these things is to do them quickly, right?
It is. That's where the continuance and bond statute of 1923.08 comes into play, though, to protect against the landlord from being harmed. As Mr. Dennett raised, we didn't necessarily dispute that, rent bond had not been paid. We wanted to proffer an explanation as to why it had not been paid and given the opportunity to correct that so that the landlord had not been damaged. So 1923.08, I think, it acknowledges that. It says, yes, we understand, but here, we're gonna call timeout, and we're gonna have a jury trial, and we're gonna continue the case so that the case can progress in this way, and that the damages are not ongoing to the landlord. It acknowledges that, and it takes away the necessity for an expedited trial.
I believe I heard the assertion that there was an admission that rent had not been paid, as well as rent bond not being paid. And if that's the case, if there is in fact an admission that rent was not paid, wouldn't a motion for judgment on the pleadings have been proper?
It could have been. I have an idea of how I would have responded to that due to affirmative defenses for failure to comply with federal notice requirements. But I think if a motion for summary judgment or a motion on the pleadings properly supported by admissible evidence in the form of an affidavit or other authenticated evidence, and then given us the opportunity to respond and raise our defenses, I think that would have been, I don't see what the issue with that would have been.
And a motion of the pleadings can be raised sua sponte, is that correct?
I don't know the answer to that question off the top of my head.
If in fact it could be, and let's imagine a hypothetical universe in which there is the eviction complaint, and then there's an answer that says, in fact, yes, I did not pay my rent.
Right.
And then asserts some affirmative defenses. And then there is a motion of some kind, and the trial court converts that motion to a motion for judgment on the pleadings and grants it. Would that have been proper?
As long as we are permitted the opportunity to respond to the motion and raise our defenses and support them with necessary evidence.
And was that opportunity given?
No, not in this case, no. Any other questions, Your Honor? All right.
Thank you.
Thank you very much.
Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Thank you. All right, our next case is intended to be a hybrid argument, and so we will take a short recess in order to set up the equipment.